And let's talk a little bit about discovery and evidence and that sort of thing. This case is 37 years old now. It's the case that came about as a result of the murder of police officer Sergeant Young. I think it was John Young, is that right?
John Young.
At the Ingleside Police Station, August 28th, 1971.
That's correct.
That's a long time ago.
It certainly is.
And to round up 8 people for the murder of one person 37 years ago seems a little strange, a little odd to say the least. So will you discuss what made them bring these charges, claiming they had all this new evidence? And
well, it's hard to know, of course, what's going on in the minds of the individuals who make these sorts of decisions, but we do know that following 9/11, there were a lot of things that were going on in the country in terms of increased funding for investigations as it may relate to terrorism,
cold cases,
cold case resurrection, and why they brought these charges 36 or 35 years later when they started the investigation, now 37 years later, is hard to know precisely. But what the prosecution claimed at the very beginning when they announced a press conference is that they had new evidence that they didn't previously have, that we have now through the process of discovery. We've been battling the Attorney General's office. And I should add here that both the United States Attorney as well as San Francisco local District Attorney Kamala Harris refused to prosecute these charges.
Right.
And so the state has taken over this prosecution and claimed that the reason that the prosecution was now being brought is because they found new evidence. And the press conference that was called would indicate that there was new scientific evidence, such as DNA evidence and various things like that, that we have now, over the process of several months during the discovery process, learned that that's untrue. That there is no new scientific technique that disclosed any information. There's no DNA evidence that matched anybody in this case. They claim now that they have a positive fingerprint comparison, but yet it is very clear that there were at least 5, possibly 6 or more fingerprint comparisons done on everybody involved in this case, as well as many, many other individuals. And none of the people who were arrested in this case were found to have been the person who left this, what they claim is a fingerprint on a cigarette lighter, until such time as in 2003 they brought it to a Department of Justice individual who then claimed that all the FBI analyses and all the San Francisco Police Department analyses previously comparisons were wrong, and now they claim to have a positive print match. But yet we've been trying for months and months and months to get discovery that would reveal their conclusions and the reasons for those conclusions, and we've been unable to get the Attorney General to deliver these documents to us.
And what about ballistics evidence?
Well, it's interesting. There's claims made of ballistic matches and so forth, but the very reason why the statute of limitations is imposed in cases like this, at least one of the reasons, is to keep evidence from becoming so stale as to make it impossible to have a fair trial or protect the concerns we have about due process. And we now know that the so-called murder weapon is missing. Hasn't been available to the defense, or for that matter now to the prosecution, for some period of time. There are reports relating to ballistics that are missing. Of course, there are witnesses who have either passed away or who have faded memories. There's all sorts of information that has been lost or destroyed over the period of time that this case has just been lying dormant. So the discovery efforts that we've been making, in addition to trying to find out what it is that the Attorney General plans to use to go forward in this case, also is to find out what evidence is missing, because down the road we're certainly going to make a motion to dismiss this case for pre-charging delay, because it's resulted in a loss of critical evidence, including exculpatory evidence that we would otherwise be able to use to prove the innocence of the brothers.
And I would like to talk about torture. In this case, Harold Taylor, John Bowman, whom we just discussed, and Reuben Scott were arrested and tortured unmercifully in New Orleans in 1973. In relation to this case, two detectives, Ed McCoy and Frank Erdelatz, or is it the other way around?
It's Frank McCoy.
Frank McCoy and Ed Erdelatz.
That's right.
Two San Francisco detectives actually went to New Orleans and used the New Orleans police to do the torturing as they interrogated these three Panthers. And they suffered terrible wounds and PTSD, and it was a horrible torture. Can you describe that a little bit and discuss that?
Well, yeah, it's very difficult to listen to the accounts that Harold tells us when he does talk about these things, because it's really horrendous what happened to these men. And the statements that were extracted as a result of these torture techniques resulted in various cases being thrown out of court, including in Los Angeles and including a early 1975 prosecution in San Francisco. The reasons why evidence was, or rather why a case was dismissed, was because evidence in the San Francisco case was introduced to a grand jury to secure an indictment, which a Superior Court judge later found was improper because these men were questioned without presence of an attorney after a judge had ordered the law enforcement officials not to interrogate these men any further without an attorney present, yet they did so. Statements were made, introduced to a grand jury, which later rendered the grand jury indictment null and void. And it was after that that the San Francisco district attorney at the time decided not to pursue those charges further. And we have been trying for several months now to find out the reasons why the San Francisco district attorney's office at that time elected not to go further with the prosecution. And I think that it's a fair statement to say that what happened in New Orleans is part and parcel of that decision.